In this video presentation, I'll be arguing that the defendant in Bido should have been granted the use of an intermediary for the duration of the whole trial, towards urging the court to grant an appeal. The defendant was diagnosed with attention deficit, behavioral problems, in addition to inability to evaluate and process new information. Though it was decided to grant him an intermediary to give evidence, the intermediary did not show up, and the case went on anyways without any help for the defendant. The decision to proceed without an intermediary resembles the outcome in R.V. Cox, where it was argued that even when an intermediary will improve the trial process, its appointment is not mandatory because the court can address the communication needs of the defendant. I'll be showing that the provision of an intermediary is actually mandatory to protect the defendant's right to a fair trial of Article 6.1 of the European Convention on Human Rights. In fact, in R.V. Great Yarmouth Youth Court, it was argued that intermediaries should be provided even when there is a small risk of a defendant not getting a fair trial, as a means of precaution. An intermediary is also necessary to comply with Robert and Zachamer's criminal evidence principle of humane treatment, accurate fact-finding, and the protection of the defendant from wrongful conviction, as it will be seen in an example later. The right to a fair trial has been discussed in many cases. In Stanford and UK, it was argued as the right to effectively participate, which means to hear and follow proceedings with the help of an intermediary when necessary. In SC and UK, it was argued that it means to understand the proceedings and what is said with assistance when needed. Rule 3D of the Criminal Practice Direction states that the court is required to take every reasonable step to facilitate the participation of any person, including the defendant, to the trial, which includes enabling them to give their best evidence, to comprehend and engage fully with his defense pre-trial and during. As argued by Brown, a vulnerable person is someone in need of support and special care because of his age and disability. In both Bido and Rashid, the defendants had issues in relation to their IQ level and ability to understand and assimilate information, qualifying attributes to be sustained by intermediary, but although this was highlighted by expert evidence, this was disregarded by judges. Hughes report that over 80% of the offending population has a form of communication disorder compared to 7% of the general population. Nonetheless, the CPD states that appropriateness of assessment must be decided with care to ensure the availability of intermediaries are for those who are most in need. This again shows the disregard of the defendant's right to effective participation, leading some of them like Joseph to not testify, risking the principle of accurate fact-finding and the possibility of wrongful conviction by the jury through adverse inferences. In his article, Werther talks about a case in 2015 where it was only possible to extract information because of an intermediary's help, including that one of the alleged victims had in fact incited the defendant to have sex with her. It could be argued that without an intermediary, the defendant would have not been acquitted or even be able to give evidence, which is the case in Biddle. Attaining vulnerability status is really difficult. For instance, in Bido and Rashid, the judges stated that there was nothing to suggest that the defendants were not understanding the proceedings or what was going on, despite contradicting medical evidence. The provision of an intermediary for a prosecution witness is regulated in Section 29 of the Youth Justice and Criminal Evidence Act 1999, together with the other special measures for vulnerable people, and is provided if the quality of evidence is likely to be compromised. On the other hand, for defendants, the provision in Section 33 is still not enforced, therefore they are left at the mercy of the judiciary, who have a common law power to appoint one. But even if the provision was enforced, a defendant must be unable to effectively participate in his own proceedings before attaining one, and this shows the inequality of arm between the state and the accused, which goes against the right to a fair trial, where each party should present his case under conditions that do not place him at a substantial disadvantage against his opponent, as argued in Salov and Ukraine. The problem of inconsistency is alarming, as judges do not think it is odd that a person with communication issues testifying for the prosecution would automatically be eligible for an intermediary, but if he appeared as a defendant in another trial, a scenario which has been occurred before, he will not be granted one, as argued by Woods. The reason why it is unlikely for a non-registered intermediary to be granted for evidence, and even so for the entirety of the trial, rests on two reasons. Firstly, they are funded by the public purse, as established in CPD 3F.16, and this creates unwanted bureaucracy and pressure to protect the funds. In Bido, the judge argued that it is not for the intermediary to dictate the duration of his need, but as found in communication Tory's website, they do not gain in any way by recommending an intermediary for more time than is needed, as they are full-time employees. Therefore, the assessment is justified, and non-compliance is against the defendant's right to a fair trial. Secondly, because of prejudice. In speaking up for justice, it was argued that special measures are not available for defendants because they are instituted to protect the victim or witness from the defendant. It is easy to see how prejudice works against a defendant such as Biddle, who has been abusing drugs and substances, or Rashid, who has used public funding to fund ISIS agenda. But it has to be remembered that the defendant, however guilty, must avail himself of Article 6 rights, and the breach of this highlights against the issue of inequality of arms and the disregard of principles such as humane treatment and accurate funding. The report continues by stating that the defendant does not need the support of special measures because he has legal representation, and in the case they find it difficult to give evidence they can decide to not give so. This thinking has been supported by judges. In RNOP, Lord Justice Rafferty placed on advocates the duty to make sure that the defendant fully participates in the proceedings in a way in which it is unnecessary to have an intermediary. There are two arguments against this statement. Firstly, the provision of granting an intermediary was established in addition to having a competent lawyer because of the need of a communication specialist. Avorto argues that intermediaries are speech professionals that enable accurate and coherent communication. Intermediaries use their experience and qualification to assess the person's need, and they advise the court on the best way a witness can be questioned. In his report, he found that many witnesses were not understanding the questions, or lawyers were making unrealistic demands on their memory, accusing them of lying or interrupting, which goes against the principle of humane treatment. Lawyers are not trained to deal with vulnerable witnesses. In the 2017 criminal law report, David exposed how lawyers go into limited training and how the accreditation to deal with such issues can be obtained simply by attendance that is not even mandatory. Secondly, the provision of lawyers is to combat the inequality of harm created by the adversarial system, since the defendant must be able to defend himself effectively against the prosecution. Thus, a lawyer's task is not the one to help a vulnerable witness with communication issues, but rather to argue a case against the prosecution. In addition, the defendant cannot raise communication issues with their barrister, firstly because the doc makes it difficult to communicate anything to their lawyer, and secondly because a vulnerable person may not even know or be aware of their vulnerability. An intermediary is necessary for the duration of the whole trial to ensure effective participation during the whole trial. Hoyano argues that if the defendant does not understand a question put to him while giving evidence, how can he understand a question during trial? In standing up for justice, it is argued that it's like granting a lift for a wheelchair person up to the third floor and then leaving him to his own devices for the last floor, which does not make any sense. The fact that an intermediary intervened a handful of times does not mean that they are not unhelpful, and the reason for this is argued by Plotnikov, because they are only sought on the morning of trial, which is too late for them to acquaint themselves with the defendant and establish that safety relationship. Another problem is the fact that judges think they can direct the court to help the defendant without the need of an intermediary. In Biddle, the judge said that the case was simple and the defendant was likely to plead guilty. Owusu Bempa argues the judges are too familiar with court proceedings, therefore they may not have a real assessment of the defendant's vulnerability. For instance, Plotnikov talks about a judge who excluded an intermediary from the review of questions but approved the question. If I said that Kelly told you that if you said Sam did something to you, she would get some money, do you agree? A 24-word double hypothetical leading question to be posed to a 5-year-old witness. Or a judge believing that an adult in her 20s with mental age of 11 should be treated as she were a normal child of 11. In an adversarial system, judges are supposed to have a passive role. By participating, they might compromise this position, in addition to having negative effect on the defendant by creating additional stress by persistent intervention. To conclude, I submit that the defendant should have been granted an intermediary for the entirety of the trial to support his right to a fair trial and the possibility to understand the proceedings initiated against him.